is formal meeting, although there are three of the five board members, but but it's really an information gathering session where I want to talk about rule changes that we want to make, and I want input from Seattle Clemency Project, who is a major and a very important player in the Clemency and Pardons Project. I talked about page limits. We want to limit to 25 pages. Where that would be the petition and the two mandatory attachments, the judgment and sentence and the infraction record, plus 25 pages would be the limit on the initial petition. And then, of course, once there is a hearing granted, you can, of course, supplement the original petition with other matters. But the original petition should be limited to the petition, the mandatory attachments, and 25 pages. The other is, once a petition is set for hearing, any withdrawal, unless it's for good cause, would be subject to a 3-year bar of submitting another petition. The other is our 10-year post-conviction requirement, where we ordinarily, except in very extraordinary circumstances, do not rehear a case or hear a case until 10 years following the date of conviction. That's for either a pardon or a commutation. The other is giving the prosecuting attorney 6 months of notice prior to a homicide case. That's because they want to do a deep dive into the record, and they also want to be able to contact the victim's family, witnesses, this sort of thing. So 10 years from the hearing will not be set for 6 months following the submission of the petition. And then what did we mean, Jennifer? Refresh my recollection on confirming their preferences on how to complete the petition for clemency. You mean how we want the petitioner to complete it?
Yes, to write the answers on the actual petition form. And then there's a board member that would like the examples that we have set out, the 10 extraordinary areas. There's a board member that wants the petitioners to touch on those examples, and that's in the policy manual. Here comes
that touches on the serious nature of the crime, the impact on the victims, and the reentry plan. All of these, and those need to be addressed, and those need to be addressed on the petition. And of course, they can also be, you can also refer to an attachment beyond that. But we absolutely need to fill out the petition as it's contemplated.
Yeah, Jim, just to clarify,
go ahead, Eva.
That when Jennifer said write, we don't mean like if you write, it has to be legible, so it should be typed, but it should be inserted so that it's readable, right, or legible. And the other is that please, ensure that you got the 10 criteria. And Jennifer's going to be the one that's going to police it, because if it doesn't meet, if you left out remorse, for instance, it'll be sent back to you. You have to complete it. If you say there's no remorse, well, I mean, that's simple, but you sort of, you be vague about, it's not going to go anywhere. Okay. So it has to be legible. If you can write legibly, fine, but otherwise prefer it should be typed. And you make sure that you have all the 10 or whatever, however many criteria that we require.
Yeah. Anyway, that's pretty much it. Jennifer, is there anything else we needed to cover? Those were I think the 5 major areas that we wanted to. John, Madison, Carla, we'd like your input. We're always in the mood or in the mind of trying to improve our processes. So I'd like to hear from you folks as to how we could do that, and what you would like to see us do differently or better or whatever. John?
Yeah, thank you. First, let me thank all of you for your work. We sure appreciate it. And I know just from watching the hearings today that everybody put in a lot of time and effort into those two commutation petitions. And, you know, you have to make difficult decisions, and we appreciate what you do. The other thing I wanted to say is that Jennifer Rome has been just great to deal with. She's hardworking. She's sympathetic to the problems and the issues that come up for lawyers and for our clients, and that's much appreciated. If I had to make a recommendation, and I've made this to Jennifer herself, it would be to push the AG's office to staff the position with more people so that she's able to handle a greater number of petitions, and it's easier for her. Jennifer, I believe, just has more work to do than a human being can do. And so that's the one suggestion I would make, is that we increase staffing on it so that it's easier for everybody. We recognize that the COVID period has been certainly a challenge, and Jennifer being locked out of her office makes it incredibly difficult. I know from our lawyers' vantage point, just things have been a challenge. It's been a challenge because Jennifer Rome has so many petitions and the backlog is significant that, just preparing all those to send to you and copying all of them is a challenge, but our lawyers are feeling that as well. I think if I'm counting correctly, Seattle Clemency petition has something like 16 or 18 petitions that have been filed that we haven't been given any notice on whether a hearing would be granted or not. So it's the way we feel it is that we have lawyers calling us saying, when is the board going to decide whether my client gets a hearing or not? And we turn to Jennifer, and Jennifer's very helpful, but there's a lot of petitions that, at least our perception is, that she hasn't been able to get to yet because of the volume of petitions that have been filed already. So that said, we listen to these hearings every time that you have them. Every quarter, we try and listen to all of them. And in March, we listened to not only the hearings, but the statements from the board after that hearing, in which you set forth the policies, the new policies, and then you voted on them. And our impression was that they went into effect immediately. And so we went to our lawyers and we said, look, we think there's a 25-page limit now. We think, we went through all the things that you just went through, telling our lawyers that, look, you have to fill out the petition completely, the form petition completely, and then you have 25 pages after that to submit to the board. The way we've approached this, the lawyers have come back to us and said, John, we have 100 pages that we would like to submit. How do we handle this? And what we've said to the lawyers is that in the petition itself, you can refer to, for example, the number of letters of support you have. Don't attach them. Simply indicate to the board that you have them. You might want to quote small portions of them, but also say to the board that, those letters are available to the board upon request. And the same is true, for example, for programming certificates, and the same is true for behavior logs. And when I put together a petition for a client, my guess is I've got 300 pages in a file. I mean, I could pick up and show you ones off of my desk here, but they're often 3 inches thick in a notebook. And so trying to pare it down to 25 pages and still have the board get a feel for all of the support a person has, or all of the comments, all of the favorable comments that people would make, is a challenge for me personally when I put together a petition, and it's a challenge for our lawyers. What I think I just heard from Chair McDevitt was that we would be limited to this 25 pages in the first submission, but if we're granted a hearing, then we can supplement with additional information, and that's great.
That's correct. I think we take lawyers at their word, as you know, that we're all sworn to do that.
Yeah.
And so if you submit a petition, let's just talk about that for a second, if you don't mind, John.
Sure.
If you submit a petition and you've got 50 letters of support, then in your supplement to the petition, or in your you say, we have X number of people that support this. We have X number of letters. We will provide those upon request. Pull a gem of some sort out of one or two of the letters, or talk about them. But again, don't shortcut to the point where the meat of your client's case is left on the desktop. I mean, make sure to either refer to it or summarize it or do something. Then when we look at that, we take the lawyer, especially you folks, at your word, and we grant a hearing. Then that's an invitation to supplement the record.
Okay.
with more.
Yeah.
All I'm doing is, because part of the problem is the problem with the backlog now is twofold. One is, as you know, the legislature was kicking around a bill that I think, had it gone into effect by around July or August, would have completely revamped the entire board. I mean, all of our present board members would be out of this high-paying job, and there were going to be 10 board members specifically selected from 10 different groups, and a whole different process. Well, as you know, John, that bill died in the legislature. But in the meantime, we were sitting here thinking, well, should we set hearings? Can we set hearings for September? Where do we go? We're kind of on the bubble until the legislature closed. Yeah. The second part of that is that being locked out of her office, when Jennifer finally did get back into her office, there were stacks of petitions sitting on the desk. And correct me if I'm wrong, Jennifer, stacks of petitions that had not been scanned yet. And it seems as though, the help that Jennifer gets is whoever draws the short straw in the office gets the, whether it's the mailroom clerk or whatever, gets the duty, and not a very glamorous one, of just feeding these documents in for scanning. And that's where it all breaks down, because you can send all the petitions you want in to sit on Jennifer's desk, but if that's as far as they go, there's nothing we can do about it until they get into the system, until our review committee is able to review them, and then say yes or no on a hearing, set the hearing and go on.
Can
So
I interrupt for a
Yeah, go
minute?
ahead.
First of all, so the last time I was in the office, my supervisor actually came into the office and scanned for me. So I do have a very supportive supervisor that understands the log jam. So that has been different and it's been wonderful. I couldn't go in this week because I've been sick, so I can't pass the safety, whatever you have to pass to get into the building. And then on top of it is I do have to review every single petition. So I weed out the ones that don't meet the minimum requirements, the 10-year post-conviction, and all that stuff. And for a while it was, if it's 10 years post-conviction, unless you request an exception. So then I had a whole bunch of commutations coming through from pro se individuals that were requesting an exception to the rule, or a family member for an individual that was incarcerated sending a petition in for their loved one that was requesting an exception to the rules. So, and that happened quite a bit last year during COVID. I actually am still working on a final count of how many petitions we received last year.
Yeah.
So just to clarify,
Yeah. So
I want to make sure everybody knows my
yeah. So
supervisor
John,
is coming in
does
and scanning.
does that answer your concern about later submissions?
Yes, I think so.
Yeah. Yeah. And the other thing too, I don't know how. I'd love to see Jennifer get more help. I'd love to see another paralegal assigned. I've kind of lobbied for that. Jennifer's kind of lobbied for that. We've talked about that. Everything was kind of on hold in her office while this bill was pending. And it wouldn't hurt even, and I don't know, tell me if I'm wrong, Jennifer, it wouldn't even hurt if Seattle Clemency Project wrote a letter to me, which I would then pass along to Jennifer's supervisor and the Department of Corrections, requesting additional staffing. I don't know what that would do, but it wouldn't hurt.
I think it actually goes through the governor, but I'll talk to Tip and come back.
Talk to Tip. But I would suggest send the letter to me, and I'll with a copy to Tip or whatever, or I'll forward it on to Tip, who works very, very closely with us. And I would love to see another full-time or another half-time paralegal, because, I have this fear on the week before hearings that if Jennifer gets hit by a bus or run over by one of her horses, the whole world grinds to a halt.
Yeah.
You know how that is. So
I do have a backup too, and you guys all know her, Tina, and
yeah.
she would step in. So I do have a backup for that.
Evelyn, Cheryl, any comments from either of you two?
No, you seem to have covered it pretty well.
And I think,
and I'd be interested in hearing Carla's comments too. Carla, does Carla have some comments?
well, let me finish with John first, and then John.
Okay, well, before that, okay, I have another. That's just the submittal. The other thing is after the hearing today, and John would probably appreciate that, we should have a time limit on each petition and a time limit on the actual spokesperson. And also the petitioner, because I felt really uncomfortable because I know that we just let them go on and on, and it's really not necessary. So the legal counsel, that's one of your main responsibilities, is to keep them to. We don't want them to just go on and on, which I understand why they would do it, but it's really not really helpful.
And
I don't like to have to step in like I did today, and when I finally find an audible pause, inject myself, thank them, and move on. I mean, I feel like I'm sort of depriving them of the opportunity to speak. But on the other hand, just like you said, Evelyn, sometimes people tend to belabor a point or go on, and it happens sometimes with the lawyers as well as the petitioners. So I think you probably do need to make sure to school your pro se counsel that, hey, you don't get penalized for being succinct. Because that means we can hear more petitions.
And I've been an advocate for limiting the amount of time on these hearings. I think if you tell the lawyers that you have a total of an hour and 15 minutes, for example, to make your presentation, then, we usually sit down and counsel our lawyers to that effect. We usually say, look, you have to do time management here. You have to figure out how long you're going to talk, and then you set limits for how long your supporters talk. And then you've got to set aside 15 minutes or so for the prosecutor and for the victims. And so that tells you how long each of you are going to be able to talk with the board. And it also limits the number of people that you're going to bring on as supporters, because you essentially want the best people to step forward and make their arguments to the board. And so we don't have any objection to the board saying, look, this is exactly how much time you get. You can use it as you choose, but you have to remember time management here for these purposes.
Yeah.
I think that's fine with us.
That's a very good point, John, and I appreciate that. The problem gets to be when you get in the middle of these hearings and people tend to often get very emotional, and you have people that are not skilled at public presentation, or they get emotional, they break down, this sort of thing, and you just don't like to step in and cut them off. You like to let them go, and so we're not going to be able to completely prevent that. But I think it is appropriate that you counsel the lawyers, hey, this board is a busy board. They're trying to hear 6 petitions in one day. So be very, very cognizant of your time and set those limits. So I appreciate that.
Chair McDevitt, I don't know if you've ever practiced before the Court of Appeals.
I have. Or
the Supreme Court. When you go in front of them, they say you get 10 minutes. And if you get finished with 9 minutes, they will say, counsel, you have 1 more minute. And then they really stop you. I'm not saying you have to be quite as, what's the right word? I'm not sure you have to be quite as decisive as that, but I think maybe one approach would be to ask the lawyers how they plan to divide up their time at the beginning of a session. And then if the lawyer says, I'm going to take 10 minutes, then at 9 minutes, you say, okay, you've got another minute, counsel. If the lawyer says to you, I've asked the supporter to speak for 5 minutes, and they get to 5 minutes, I think you can say to them, certainly in a polite way, thank you very much. We appreciate, finish up your paragraph or whatever. But I think you can politely say to people, we have time limits here. We don't have any objection to that.
I've been told by both the Court of past years, by both the Court of Appeals and the and as a matter of fact, my old first assistant U.S. attorney is now a federal district court judge, Judge Rice, and I went in there one time to vouch for the new United States Attorney, and he kidded me by saying, "I've read your materials, counsel," which is which is telling you, you know, you needn't say much more.
Right.
Jennifer, you had something? You had a
Yes, I just wanted to clarify too, behind the scenes, I do a lot of prep with the attorneys. So for example, today, Kevin Kehoe, he actually had exactly, and I watched the clock because he told me I have a 12-minute opening. I have, and he like really structured his speakers, and we go through that. That's behind the scenes. I think this morning with the first case with Brian, what had happened is I planned it for an hour and a half because the family members of the victim weren't planning on giving testimony, and I ended up having conversations with every single one of them yesterday, and even doing a Zoom practice with those who attended the hearing. And we had no idea. They all told me they got notice 2 months ago, but they did not, come forward till like the last minute. So that was part of the scheduling thing. And on those types of cases, the ag martyrs, in the past, the board has said if the family wants to give testimony or participate, we would extend it a half an hour for them.
And we did. That hearing this morning, although we got a little bit of a late start, for technical reasons, that hearing went just about 2 hours to the minute, which is what we had planned for, because it was a very ag murder one case that did require a lot of testimony and a lot of victim survivor testimony. Carla, you've been very, very quiet over there. How can we serve you folks better?
For us, it's always time, but I don't even know if there's much change that can happen for that. A lot of it is just due to the legislative changes that are happening and new Supreme Court decisions that are coming down that are impacting our caseload. And I think you guys know, probably a year ago, the year of 2020, we created a sentence review unit to incorporate our clemency work, our ISRB work, and our resentencing work. So our workload is increasing, and we also do wrongful convictions and innocence claims under that unit. And that unit is now what the Deputy Chief of Staff is responsible for. So my workload has increased, and we want to give each area adequate time, and clemency is something that's just really important for us. We want to be able to participate. So timing is important. The time that takes the most energy is really reviewing those old cases. We have to retrieve the materials. They're older, so they're not just sitting in offices, they're in archive. So we have to pull them out of archive, and then we have to start digging through the materials and start looking for what we need. Plus we have to notify victims, law enforcement, and that's not the only case that we're looking at in any given time. So sometimes the ag murder cases really do take their toll on us, just because we believe in the thoroughness of our review. And so any case that comes to us, we're gonna try to do that deep dive and make sure we give it that adequate attention. So really for us, it's just timing. Jennifer's been marvelous. You all have been marvelous. We really appreciate the relationship we have with this board. But we do recognize that the work that we're doing is encouraging more people to be hopeful and to file petitions, and the work that the Seattle Clemency Project is doing in partnership with us and others around the state is encouraging people to file more petitions and make these requests. So it seems, I like John's suggestion that we try to find ways to get Jennifer more support, because right now she's doing an excellent job, but we also recognize that she's under a lot of pressure like some of the rest of us are.
Yeah. Carla, those are great comments, and we really appreciate the work you do. And I understand how your work, the court hasn't made it easy. The Supreme Court hasn't made it easy on you with some of their recent decisions. One of the things we want to do, because we've seen a couple of these, is folks that have parallel tracks of a, and I think we have 2 or 3 of them, where they have a 6164 request in with you folks, and at the same time they kind of hedge their bets with a clemency petition. And so one of the things that I've suggested that we change our petition, where we said, have you, something to the effect, have you exhausted all your remedies? We want to specifically state in there, including a, however we want to word it, a 6164 request, because it does us no good to have that pending with the prosecutor's office. At the same time, there's a petition for clemency working its way through our process. That just creates unnecessary work for both you and for us. Yeah. So I think we want to be very, very clear that when we say, have you exhausted all of your remedies, that includes, have you filed, unsuccessfully a 6164 request. Does that make sense?
Yeah, that does make sense. And I think last year people were really frustrated because the court, our superior court, had told us that we shouldn't file any 6164 petitions because they were just so backlogged with just the backlog related to COVID and limited court operations that they just couldn't meet the demands. And so they asked for us to hold off on any discretionary petitions or motions, and we honored that request. So what we found people doing was they would still push forward the request, the 6164 request with us, but because they knew we weren't going to be doing anything other than reviewing the case, and then it was just going to sit in a queue, they also filed a petition with you all. They let us know that they were going to be doing that, but it was really hedging their bets because the 6164 process was taking so long because of our courts asking us not to file those petitions.
That's interesting, Carla, because I didn't know that. I did not know that tells me why we were getting some of these, but I didn't know that your court has said, forget about filing them. We won't even look at them.
Not until this year.
That's a problem.
Yeah, they just started looking at them, or at least accepting those motions this year. They told us to hold off until early 2021. And then there were some other decisions on the Supreme Court level limiting court operations. And we didn't start filing petitions, at least any kind of mandatory or discretionary resentencing petitions until May of this year. So that probably, the cases that you're referring to, they probably are King County cases, and that was probably why the lawyers were doing that. But we can also be supportive, and when the lawyers ask us, should they file both, we can let them know that the Clemency Board would like them to exhaust all options. So, maybe reconsider trying to have a simultaneous process.
Yeah. Good.
May I interject? Jim, some of the feedback has been as every single county handles the 6164 process differently.
Oh, I can imagine.
So maybe we should do a meeting when have WAPA send out an email and then, again, touch base just so that we can all get on the same page. Or like a stakeholders meeting.
That might be a good subject.
When we have free time.
that might be, usually we get invited to speak at WAPA, and that might be a good subject of conversation. I would suggest that maybe we and Carla, you might want to bring that up to Dan.
Yeah.
It might be I don't know when the next WAPA conference is.
Is this? I think it's starting soon, actually.
Yeah,
I think it's this month.
Yeah, but that might be, maybe for the future, that might be a good conversation to find out how the different offices handle those. so we don't get in each other's way, I guess is what I'm saying. So, John, you had something?
Well, I wanted to comment on that. You know, I agree with just about everything you've said until you got to this point. The the 6164 petitions are, first of all, handled differently in every county. And there is no speedy trial requirement or speedy resolution requirement. And so I can file a 6164 request in Spokane County, for example, and I may never get a response to that request. And to say that I've got to file a 6164 request and get an answer and a resolution before we can file a clemency petition just ignores the fact that many of these prosecutors just won't respond to us, won't respond to our clients, won't respond to us. And we don't have any idea if they ever will. There's no requirement that they respond to a petition. It's totally discretionary, and it's totally discretionary for them to simply ignore the request. And so to say to people, you have to wait until you've filed that request and you've gotten an answer back before you can file a clemency petition just seems inappropriate to me.
That's a good point. And again, this is why we wanted to do a listening session, for just this very reason. Because as it turns out, you know, the more you get into this, the stranger it gets.
Yeah.
And I can sympathize exactly with your. I mean, if you file something in Okanagan County and it just goes in the bottom drawer and never gets acted on, then you're going to wait forever, and that's not justice either. And I don't have an answer right now. I think we're going to have to think about that. Probably talk to our esteemed counsel, who's there, standing out in the cold in front of the office building, and maybe talk with a few of the folks like Dan Satterberg and some of the others, and see what WAPA can do, if anything. Because because you're absolutely right. If one goes to a prosecutor's office and never gets any action, then that's a shame on us, because that is appropriate for a petition to be filed. On the other hand, if it goes to Carla Lee, I know she jumps on these things right away, right. And she promises same day service. Then it's a little bit different.
Mm-hmm.
But
that's what I was going to say, Chair McDevitt, is like for us last year, we received about 234 6164 requests, and we responded to all of those requests. We declined most of them, but people did get a response, and then we have probably about 75 6164 requests in our queue. But because Senate Bill 5164 passed, dealing with the persistent offenders, and that's mandated, we've had to put those 30 cases ahead of those 70 6164 cases in our queue. So right now, we're busy with those persistent offender resentences, which on some level will take some pressure off of the board, because now you don't have to deal with those persistent offender robbery in the second degree clemency petitions. You won't be receiving those anymore, because 5164 takes care of that. And prosecutors are mandated to resentence those individuals. And that's who we're focused on right now.
Well, one of the things, Carla, that you said that's important here is that you at least notify the petitioner whether there's going to be any action on it. Is that
right?
That's
we
the case?
Decline. We'll
now,
send a decline notice.
Yeah, what John is saying, which concerns me, is if you don't get a decline. I mean, obviously, if you get a decline notice, you've exhausted that remedy and you
Yeah.
come before our board. On
Right.
the other hand, if you get no notice at all, it just goes into outer space, then what do you do? And I guess that means that's something that maybe WAPA needs to address.
Needs to address, yeah.
Uh,
But in the meantime, what could possibly happen is you could still ask them if they made a 6164 request and if they've received a decline notice.
yeah,
In which event, if they have, then you can say, okay, they've exhausted their options. But if they haven't, you know, I don't
Yeah.
know what we do there, but you could at least still ask.
Yeah.
And that will even give you some data on which prosecuting attorneys' offices are responding and which
Can-
ones are not.
Can I interject?
Yeah.
go ahead.
When I have learned that there's a 6164 request that's pending, where we have a petition, I have actually reached out to the prosecutor myself and just said, hey, how's this going? And John, you probably know Forrest Hope's case, Snohomish County, Adam Cornell and Forrest Hope have worked closely with me on the status of that petition. So if we have that box on the petition form saying, did you do that? Maybe I hate creating more work for myself, but it's going to happen. Maybe I'll reach out to the prosecutor and say, what's the status? And can get some feedback on it before I have you all reading a petition. But lots of thought needs to go into what we do with it, but just to give you some information on that.
Well, Chair McDevitt, I can think of a handful of 6164 requests that are just sitting with the prosecutor and we don't have any response back. I can think of one that is with the Spokane County prosecutor, for example. I won't go into detail, but he has acknowledged receiving it and has said he's thinking about it. But he received that back last June 2020 and is still thinking about it. So I would resist any specific rule that says we can't file a clemency petition until, after there's been some resolution of the 6164 request.
I will say,
I completely agree and sympathize with you, John. Because that's the importance of what we're doing right now.
Yeah,
is I'm finding out things from you and Carla that I was not aware of. The court not accepting them, prosecutor's office not acknowledging them. It's too bad that the statute itself didn't put some sort of a deadline like
right.
Many statutes do. And maybe that might be a legislative fix, but that's not going to help you today. So, but I appreciate that. And we need to do some thinking about how we deal with that, because we don't want to, on the one hand, we don't want to have a 6164 petition being acted upon by Ms. Lee at the same time we're considering a petition. But at the same time, we don't want one that's just sitting in the queue in Spokane County, growing moss, and not enable the petitioner to file with us. So, because that makes no sense at all. Any Evelyn or Cheryl, any thing on this issue or any other issues? Don't be so vociferous. Anything else before we close out? Because this has been very helpful.
Could I raise one other issue?
Sure.
I'm not sure what the answer is here, but you mentioned this withdrawing a petition and then having a 3-year requirement before filing again. And I just wanted to let you know how this works sometimes.
But
And
that's only if it's been set for hearing.
well, what we have found on several occasions is we get set for a hearing and then something happens. And that something might be as in, let's see, as in, yeah, I mean, you'll remember the Gabriel Garcia case, for example, which was all of a sudden the victims were up in arms and there were threats being made. And, you know, Jennifer Rayum came to me and explained what was going on. And I went back to the client and said, you know, do we really want to go ahead with a hearing at this point? And we both decided that didn't make any sense. And given the threats that were being made and so forth. And so I understand, of course, that you want these things to go smoothly. We do too. We want as many hearing sets as we can possibly have. But on occasion, things happen that would suggest a requirement of a continuance of the date as opposed to prohibiting the person from going ahead until 3 years have passed.
Well, that's when council, I mean, you know, none of these are baked in concrete, and that's when council, just like an illness or that's when council needs to be as honest as possible with the board, or honest with the board, and talk about extraordinary circumstances, because we can and will continue for extraordinary circumstances. But when you just do it, and this has been the bane of courts forever, as long as 46 years I've practiced, where the, you know, continue. I mean, that's the courts have never figured out how to completely stop that, nor have we. And all we're trying to do is say, when we've set you for hearing, because we've reserved that time, then we want you to go forward. Now, if some kind of a calamity happens, and we don't want to define that, I mean, that depends, then of course there's an exception to that rule. The earlier, the better.
Okay.
We've had deportation, potential deportation cases, and I've got this on. I mean, I've asked counsel on the record. You know, all of a sudden they come rushing in with their hair on fire. We got to have this. We got to have this. Our client's about to be deported, and we need an expedited hearing right away. Well, counsel, when did you know this was a possibility? Oh, last winter.
Yeah. Well,
great. Why didn't you do something then?
Right.
Anyway.
The final thing that I have in my mind, and I don't have an answer for this, but is, as I watched this morning's hearing with Charles Graves, you know, he was a client he was a person that I met with. I looked at what he had done with his time, and what I don't have, and what the Seattle Clemency Project doesn't have, is early input from the victims. And I don't know how we deal with this, but I think that if I had had a chance to learn how hurt the victim's daughter was, I thought she made a powerful witness against granting clemency, and as the board did too, I believe. But it would be nice to somehow get an earlier idea of how strong the victim's opposition is.
Can I interject?
I don't think, John, I appreciate that, but I don't think that's going to happen, because there's no, I mean, I do appreciate it, and sometimes it's blindsided. I think the best thing to do is to assume, in a case that's a serious case, assume right up front that there's going to be strong opposition. Make that assumption right away. And if you're surprised, great, because I grant, and the board has granted a lot of leeway to the victims, because the victims are often left out of the equation in this. And every time when you have a homicide case where 22 years after the homicide, all of this is brought up again, it is very, very painful. And you see that, very painful, very hurtful. Sometimes you have people that say, I don't want to get involved. They want to forget it. Sometimes they're terrified, horrified. And that's the reason why we allow victims to make submissions as late as the day before the hearing. And I guess I would say that's probably just something you're going to have to live with.
I fully understand that. What goes through my head is I think if we know ahead of time that there's incredibly strong victim opposition, it may be that we wouldn't go ahead with the hearing. I don't know if there's a mechanism for finding that out early, but
probably maybe even a discussion with the prosecutor. Carla,
I would
can
say,
you weigh in?
Yeah, I would say, I think in most of the ag murder cases, John, you're going to see that pattern. At least that's what we see. The more violent, if it's a homicide, if it's ag murder, you're going to have victims that are pretty hurt, and their wounds are being reopened every time those petitions are filed.
Yeah.
The less violent, the more likely the victims are probably going to not really get engaged, or when they do get engaged, they may be willing to forgive. They may have healed beyond that harm. But ag murder, you're definitely, you should assume the victims are going to come forward and that they're going to be pretty hot about it, because they're still healing. There's a loved one that's no longer with us in those murder and ag murder cases. And it takes an extraordinary person to be able to get to the end of their forgiving and healing journey and get to that place of supporting that petition.
I totally hear you. I totally understand that. We end up getting a fair number of requests on murder cases. And I understand that there's going to be victim opposition on many of those. But trying to figure out how to use the board's time wisely and how to decide which cases, particularly on homicide cases, which cases to actually bring to the board. Look, I don't know that this can be done, and maybe I'm dreaming, but it would be helpful if early on we had a better sense of how strong victim opposition is.
I think, John, I think a discussion with the prosecutor on the case, maybe even before the petition is filed, or I think, and Carla, tell me whether I'm right or wrong on this, but I think a discussion with the prosecutor, the people who've handled the case and knows the emotions or can at least recall best they can the emotions and this sort of thing, could probably be a pretty good gauge as to what you're going to run into at a hearing. And the Graves hearing this morning was a good example, or a bad example, however you want to look at it, of folks who came in late to the party, but were very, very emotional about it. But I think that when you're sitting with those, and I don't envy you, when you're sitting with that case and you're counseling the petitioner on let's say an ag murder case, I think the first thing I would do, but I don't have the experience you do in this regard. I would call the prosecutor and say, hey, I've received a petition on this. Do you think that this has any chance of going forward? Here's what's happened. And the prosecutor is going to have his or her finger on the pulse of what has happened within the community, within the in the victim's family, this sort of thing. That's about all I could tell you that might make your early decision whether or not to file a petition at all.
Yeah. Carla, you may be able to answer this better than I can, but if I were to call you with a brand new petition that where the crime happened 30 years ago, my assumption is that you're not going to know very quickly whether there's strong victim opposition, and you're probably not even going to call the victim until we know whether there's going to be a hearing on the case.
Yeah, we don't notify victims until the board sets the hearing, because we just don't want to re-wound them if we don't have to. So once the board lets us know that the board is going to hear it, that's when our notification process is triggered, and we'll start trying to identify where the victim is located, because our information sometimes in our system is old because the cases are old. Once we locate the victim, we've changed our protocol a little bit, or now we call victims and we send them a letter. And then if they want to talk to us again, we make ourselves available for any further contact with them. And now we're also offering victims very limited victim services. So if they need to be connected to a victim services provider in our community, we will try to locate those services for them. And we also have our director of victim services on standby in the event they need an immediate victim advocate to walk them through any healing issues that they may be dealing with at the time. So we're trying to really put more resources and more intentional thought into how we handle that. So we won't really know. We may know because of the original trial deputy, and maybe still in our office, and they may have some feedback for us, and we may have an idea of where the victim's going to go, but it's not until we make that contact. But I will say, in those violent cases, though, that's where we're seeing victims where they're just not so sure what to do, and they're troubled. They become fearful. They are concerned about their safety. But in the 3 strikes cases where people generally felt that a sentence was beyond, ideals of justice, that's where you see victims being more supportive, or they're just ambivalent and they don't care either way.
Chair McDevitt, could I loop back then to once we set a hearing, then if you pull the petition, you have to wait for 3 years? Because my sense is exactly what Carla just said, which is we're not going to find out about strenuous victim opposition until after the hearing has been set. And so if we find out there's really serious victim opposition at that point and say we shouldn't go ahead with the hearing, I'm not sure that it's a fair thing to do to say you can't file for another 3 years on this case. So it's just something that I've been thinking about. I'm trying to figure it out myself, but we don't learn about strong victim opposition until after the hearing has already been set. And then if we find out it's really strong opposition, we might go to our client and say, there's no point in going ahead at this time.
I think, though, John, and I appreciate the dilemma, and I don't know that there's a ready answer. I think as Carla said, I think in an ag murder case, you've got the experience. You have the experience. Sometimes your pro bono lawyer or pro bono lawyers, like with Microsoft or something, that don't have criminal defense background, but you folks are the gatekeeper. And when you look at a case like that, and it's an ag murder case, you can absolutely assume there's going to be strong opposition. I mean, I would say that's the starting point. Then you look, you balance the strong opposition. You assume there's going to be the strongest opposition known to mankind, but then you balance what has transpired, you know, whether the individual has used his or her time productively, the infraction history, all of these other factors that we look at, and balance that against what you assume to be strong opposition. And I think that's, in my view, that at this point in time, that's probably the only way you're going to be able to deal with it, because these folks, as Carla pointed out, this is painful. Sometimes they don't decide to get involved until the last minute, because this is really reopening old wounds, and you see what the result is. You saw that today. So,
yeah. Well,
anyway, I want to let my rest of my board go. It's costing me overtime. They get time. Cheryl and Evelyn get time and a half for participating beyond.
yeah, I do too.
Evelyn, do you have anything to add to the mix here? Anything we've talked about?
Well, I want to say thank you to John and to Carla, because in a way it's extra work for Carla and John, but I think that what Jim has said is really quite, if you follow the recommendations, I think it'll make it a lot easier for your job and for our job. Because it's tough. I mean, like the first case today, I was basically on the fence to begin with. And then, so then the question is, what would have happened if, we didn't hear from the other side? But, my philosophy always, put yourself in the other's shoe. How would you feel if you were the victim's family? Or, so then you kind of think you sort of talking to yourself. So that's number one. And the other two is then think of yourself in our shoe. If you put the application in, how would you feel if you were reading it, representing the board? So always do your homework, and I appreciate it. It's tough, but that's what it's about, So, but thanks, Carl. I read about you in the paper too. So,
as a matter of fact, I saw her picture in the paper just recently.
You're right.
Thank you. That's our 5164 work in action.
Yeah.
You hit the big time when you're in the spokesman. Your picture's in the spokesman review. Cheryl, you have any input?
No, other than I agree with what you said, Jim, that it's you just have to know your audience. If these ag murder cases they're definite, it's going to be opposition. There is no way that it's just not going to be opposition. So that's how you have to approach it, that you are going to have the opposition. One thing that I would say is these cases that have been accepted for hearing, and you guys all know this, but a lot of time goes into reviewing each of these cases. And for us to have done all the work to get to hearing, and then once the hearing starts or just before the hearing starts to say, okay, no, we're going to withdraw, that just wasted our time, and someone else could have had their hearing that day.
Yeah.
So, it's a difficult decision, I know, but it would be to the benefit of a lot of people to know that before filing that petition. So to do the legwork beforehand as much as possible, with the assumption, especially in these murder cases, that there's going to be opposition.
Thanks, Cheryl. Good comments. Anybody, Madison, anything to say? Or I see Zoe is on the line down there, but I don't know. I haven't seen anybody down there.
Oh, Zoe, she actually
She's the
interned with
paralegal?
Seattle Clemency,
Oh, no.
and now she works for Carla.
Oh,
Yeah,
oh,
she's the paralegal for the
Oh.
work that I'm doing.
Carla, any further comments from you, Carla?
No, I just, there was a question that I had put in the chat just, and I know the board has contemplated this before, but I just wondered if the board would be opening to making the time period, the waiting time period for ag murder cases 5 years versus the 3. And this is really me just thinking about the victim community. I know for example, the Bachmeier case, that case really is troubling for the victims, and they have expressed that the 3-year period appears to be harassment for them.
You mean the refiling, once a petition is declined, that the refiling period be 5 years as opposed to 3?
Yeah, and even if the board hears it and they deny and the governor denies, could it be a 5-year wait period? And
No.
we just have some ag murder cases where victims are just really concerned about the 3-year period.
I think the board, we can talk about that. I think that's probably a reasonable request, but I think we'll talk about that, and that may be, we'll discuss it, and that may be in the offing. But I do agree. I'm always sensitive, just as I'm sensitive to the petitioner, I'm sensitive to what the victims go through, and we see this painfully every time we have hearings. So thanks for that input, Carla. John, anything else?
The only other thing that goes through my head is when you talk about lawyers addressing the 10 areas that I think are listed on the website. Do you want the lawyers to do headings to that effect? I should say that when we deal with our lawyers, we're doing several things, but it includes go read the Clemency and Pardons Board website. When you're doing a petition, you're going to need to address all these issues, but we don't tell them to put it under headings like this. I think, for example, if you had a heading that said remorse, I think we would say, yes, he has plenty of remorse. What we've said to our clients or to our lawyers is, obviously, you're going to need to address this somewhere in your petition, but we have not said to put it under headings like this. Is the board saying that you want it under a heading? Or is it fine?
I don't know that we necessarily want it under a heading, because if we did, we'd change the format of the petition. But I do think that somewhere that within the initial petition, as many of those factors that can be addressed should be addressed.
I agree.
And I don't think we need to say, I don't, it's too easy to check the box, remorse, yes. Serious nature of the crime, well, maybe this or that. That's, if we do that, we might as well computerize the whole process, including the hearings.
Okay.
So I think if we, and Evelyn, I want you to weigh in on this, but I think if it's clearly set out that to the petitioner's counsel, you better address as many of these as you can, because that's important. I think that's what's important. Evelyn, is that where you're?
Yeah, it's not just yes, no. It's just, you've got to verify or prove that that you meet the criteria. Yeah.
Okay, that's fine.
And that we can read, and it should be legible, okay, please.
Thank you.
Good. Well, this has been very productive. Thanks to my 2 board members who stayed on for overtime. You'll be duly compensated for that. Carla, thank you for your continued support of the board. John,
Thank
you
you.
too. I haven't seen you at the Starbucks in Madison Park lately, but they're starting to let people sit inside, so I expect I'll see you here shortly. So, Madison, Joe, thank you very much. Katie, thank you for being such a good trooper. I haven't, Katie, do you have any input that anything we've said here?
No, I don't, but thanks.
Good. No. Okay, thanks. Jennifer, thanks for setting this up. We'll see you all in September, I guess, huh? Thanks.
Yes. Thank you. Bye.